going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you guys are having a great day so far. I've got a good one. Got a judge out of Michigan. I mean, I don't even know why I say that 90% of my clips are out of Michigan. Anyways, this is Judge Schaefer, I believe his name is. This one's interesting. And I don't know what to title this video, so that's why I just kind of randomly picked something. But what do you guys think? Is this defense attorney victim blaming, or is his defendant actually the victim here? It's an interesting case. You're going to have to hear it. You're going to have to make up your own opinion. I'll try to keep my opinions to a minimum so you can so I can hear what you guys think. All right, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
If we call the case of People v. Jeffrey Winninger, this will be case number 24S19062FH. We're here today for defense motion as well as a defense motion to amend the contact order.
I'm not finding you live.
Is it motions?
Okay, Mr. Franklin.
So we would like to have the no contact order amended so that my client can see his children. This is based on a couple of things. One, the actual incident that is in the trial. He made no threats, nothing at all toward the children. And obviously, I mean, this came out at the preliminary exam. We don't have a transcript for the court, but even based on the police report, the charge comes from my client having a hammer, telling the complaining witness, if you come any closer, I'll hit you, which to me sounds like a conditional leave me alone. So that's what he's charged with here. That's why he can't have contact with his children. He didn't go running around the house wildly waving a hammer. He'd had enough of his spouse, and rightly so, because as my motion sets out in March, she made false allegations to the police that are almost identical to the ones that she's made in the case we're going to go to trial in, where she says he beat her up, and then later she recanted. And then we go to the exam, and she said, quite convincingly, no, I lied when I told the police I recanted that. Well, we got some text messages, those are attached, and clearly from what we're reading in these text messages, she's admitting, yes, I did hit myself in the face to make it swell up, which is a horrible thing to do. To beat yourself up, call the police, and get the father of your children in trouble. Now, she did do the right thing in that instance and call the police and recant, but now she's recanting her recantation, which is a long way of me saying I'm going to have a lot of fun with this at trial because nothing she says is credible. So that there are no allegations that my client has done anything sinister toward his children. There's just none of those allegations. There's no reason that he can't have contact with his children. My understanding is the complaining witness here has not filed a PPO. My client is so dangerous. Why hasn't she done that? He's done this so many times. Why is there no PPO? And there's no order with friend of the court.
So we see enough PPOs
Might that be because there's already probably an order in the criminal case? Why do we need to duplicate things and have the court doing things twice?
Well, if your case is gonna fall apart and you really feel you need that protection, you always want extra protection. But there's no filing in front of the court, which to me says she thinks this is gonna blow over and they're gonna go off into the sunset and back home and everything's gonna be, fine as normal. But that those two things haven't been done tells me all I need to know about these allegations. They're just hogwash. And if she does go and file for a PPO after I've highlighted this, that would tell me that she's trying to manipulate the system. But I'm getting off the trail here. The point is that there's no reason that Mr. Rinninger can't have contact with his children, even if his mother has to be there, that's fine. He just wants to see his kids, and it's time for these lies to stop keeping him from his kids.
So help me out, because I don't know that I saw this in your.
All right. I wanted the attorney to finish speaking before my first break. Okay, so we kind of have an idea of what the charges are. Well, not the idea. We know what he's charged with. And this is where I'm asking. Is this attorney just blaming the victim? I mean, he is. But I want to know if, who's right and who's wrong here. And I guess I'm asking you to be the jury. That's what the jury is going to have to figure out. If it's a jury trial, I don't know if it's a jury trial or a bench trial. I think they may say that here in a few minutes, but interesting. But yeah, if I'm holding a hammer above my head and I'm saying, I'm going to hit you, we take another step, that's a threat. That attorney, I guess good job for defending your client, but that's a threat. I'm sorry. Yeah, it would scare the shit out of me if someone did that to me.
Motion. How old are the kids? Did the kids witness this? I saw in your text somebody referred to as Kenzie. Is Kenzie one of the children that ended up calling the police? I don't know anything about that.
No, Kenzie's cousin. Only child. 5 and 2-year-old.
So were they home during the incident?
No.
Mr. Butler, what's your position on the request before the court?
Well, Your Honor, clearly the defendant was so intoxicated at this time that he doesn't even recall that his children were there when they were there. As a matter of fact, if you read the report that was submitted by Franklin as an exhibit, which always happens, exhibits. But anyways, you'll see that the child was there. On this day, it's alleged the defendant had in a long-term alcohol drinking binge and that has significantly impacted the family. The victim had noticed the defendant was still intoxicated by alcohol from the night prior. She is in court today. She's sitting with him. He had made requests to leave the home to go with more alcohol, and he made statements about threatening to kill himself. The victim didn't want him endangering himself or others and wouldn't permit him to drive to the residence. He demanded his keys from the victim. And during this time, the victim began video recording his actions. So we have that. Again, this went through preliminary examination. None of this material was she was cross-examined on it. So she's recording his actions. During his recording, the defendant is using profanity, acting extremely aggressively, makes physical contact with the victim, grabs herself on her hand, all while the young child is in her arms. Shortly thereafter, the defendant grabs a drywall hammer, so that's a hammer on one end and a hatchet on the other, and then makes threats. He then jumps from a first-floor bedroom window and makes his way to the wagon wheel, where he's picked up by the Portland Police Department. And the officer noted that he was extremely intoxicated and had a small bottle of vodka shoved in the front of his hands. So all this was flushed out during the preliminary examination. Judge Bowles presided over that. He found the victims, Judge Bowles, why she recanted her statement from the previous allegation of domestic violence that had occurred. She made statements about why she had done that. That was obviously enough to convince a very seasoned judge or prosecutor to bind the case over on this kind of performance assault. So with that, Your Honor, I'd ask that we not amend the defendant's bond conditions to allow contact with children. Because besides this case, he also has a 2013 conviction for assault and battery, a 2013 conviction for retail fraud third degree, a 2013 conviction for chemical agents prohibited uses, meaning he was using something to get high high basically that it shouldn't have been. In 2012, he has a larceny under $200. In 2019, he has a conviction for OWDI for marijuana out of this county. So based on the totality of the circumstances, I ask you not to amend the bond.
So the purpose of bond and
All right, before Judge gets into the purpose of bond, I think we all have heard the purpose of bond speech, and they have to put it on the record. Anyways, so there's the prosecution side. Now, this is the fun part. How do you balance this? The defense is blaming the victim, and the prosecutor's like, no, this guy's not a good guy. So what do you guys think? Victim blame, or is the defendant actually the victim here? Let me know in the comments what you guys think.
the conditions surrounding bond are twofold. It's to ensure the appearance of the defendant. I haven't heard any argument here about Mr. Ringinger not appearing for court dates, or that he would not do so in the future. The second prong of bond is to protect the public. That would include individuals involved in the case. Now, in this case, we have an allegation of felonious assault, and there's also a charge of domestic violence. Those apparently involve the defendant's significant other, wife, I guess I don't remember which it is. And that, according to people here, at least one or more of his children were present during this incident. And I mean present in the home, not necessarily witnessing. I don't know that I have enough information to make that determination yet. And so we have a bond order that does prohibit contact between the defendant and the complainant and her immediate family. And often in these domestic violence situations, the purpose of that prohibition or prohibition, I should say, about immediate family is so that we don't have undue influence. Using children, for example, to get messages to a complainant, or using children as a messenger that otherwise would not be available, or using children to put undue influence on a complainant. All those types of things that we see often in these situations. So it's a long way of this court saying that as I think about bond and the conditions imposed here, they certainly appear reasonable. They certainly appear to be fashioned in a manner that addresses the court rule. In this case, we have a pending domestic violence case, a pending felonious assault case that involves two individuals that share children. And it makes perfect sense to this court that until we get that resolved, that the prohibition of contact with Ms. Parks and or her immediate family makes sense for now. Mr. Franklin, you certainly can raise the issue again. I don't know if there's a companion probate case at all, maybe not. But for now, the court respectfully is going to decline to amend the bond conditions. Thank you.
All right. I let that play a little too long. I meant to pause it right before the end. All right. Agree with the judge, disagree with the judge. Let me know in the comments. Thank you so much for watching. If you haven't done it already, please hit that like button. That's all I got for now. Until next time. Bye.